Hello, everyone. My name is Kelly Young. I am legal counsel with the Justice Collaborative. Welcome and welcome back to some of you to the latest installment of our Blueprint webinar series. For our newcomers, the Justice Collaborative's Blueprint for a Safer and More Just America is a comprehensive framework for national criminal justice reform geared at ending the dehumanization that has criminalized extreme vulnerability and created an incarceration crisis. It's building in its place in America with dignity and freedom for all of us, starting with those who are the most vulnerable. And I want to thank our justice volunteers who over the past year have helped us do just that through research projects, media amplification, and on-the-ground action. You are all amazing. And one of the key principles in the Blueprint is to strengthen people and communities. And one of the ways we do this is by making sure that we are not needlessly making people who are incarcerated more vulnerable and traumatized. And today our panelists will be digging into how solitary confinement does just that and the ways in which we can end its practice. So joining us today, we have Ken Oliver, paralegal and staff organizer with Legal Services for Prisoner with Kids, Katie Rose Quant, staff writer and editor with Solitary Watch, and civil rights attorney Ann Butterfield Wiles. Thank you all for being with us. And unfortunately, Florida State House Representative Anna Eskamani is currently on the House floor and will not be able to make today's webinar. However, she has sent along a recording which includes information about the really important bill she's championing aimed at specifically keeping our young people out of solitary confinement. So be sure to look out for that in the follow-up email to today's webinar. And as we start the conversation, for all of you tuning in, if you have any questions, please feel free to write them in the comment box along with your name and where you're from. Or if you're watching on Facebook, just throw it in the comment section there, and we will do our best to get to as many of those as possible. And I also encourage you all to tweet during the webinar to share your reactions and what you're learning. And so to kick the conversation off, our panelists are going to begin by framing the issue and explaining why we should care about solitary confinement and why ending or limiting its practice should be high on our criminal justice reform agenda. And so Ken, can you get us started?
Sure. My name is Ken Oliver and I work for Legal Services for Prisoners with Children. I'm a directly impacted person. I served 24 years of a 50 to life sentence, 8.5 of which I served in solitary confinement as a result of an erroneous gang validation that occurred within the California prison system. I was part of one of the mass hunger strikes that resonated throughout the United States in Pelican Bay and Corcoran Prison. People should care about solitary confinement. I can kind of sum that up in one word because it's torture. Sensory deprivation has been shown through the data and the science to harm human beings. And the state utilizing such a device or mechanism to contain or otherwise neutralize human beings is nothing short of torture.
My name is Ann Wiles. And all respect for Ken Oliver and all the men who have suffered this unbelievably horrible years and years of torture, and it is torture. So I'm part of we had a class action lawsuit that we filed in 2012 in California, a class action trying to end solitary confinement in California. We focused on the SHUs, the security housing units in the state where people had been tortured literally for decades. These SHUs opened up in the late 80s, first in Corcoran, and then they built Pelican Bay in 1989. And it was specifically created architecturally to house people in solitary confinement. And when our case flowed from the hunger strikes of 2011, and then we had already filed the lawsuit 2012, and then the leaders of the hunger strike, they're called the Short Quarter Collective at Pelican Bay. These men, and they have a 4 reps council. They issued basically a call to hunger strike, and in July 2013, 30,000 prisoners came out on strike in California throughout our prison system. California is the largest prison system in all the United States. It had a number of lawsuits up until to the Supreme Court, where ultimately, they had to limit the number of prisoners they had. But our lawsuit was focused on the shoes because, as Ken mentioned, people were validated with no evidence, with no behavior, no acts of violence, and they ended up in the shoe. When we started our litigation, there were 2,000 men in solitary confinement at Pelican Bay. 500 had been there for over 10 years in solitary, and about 100 of them had been there for, over 20 years. So it's a crime, and it's a longer discussion, and I'll stop, but it has actually, there's so much evidence that has permanently damaged human beings, and that's a whole nother discussion. I have studies that Kelly's going to send you that flow from our lawsuit, as well as from a recent study the Danish group of scientists wrote, which basically says that the mortality rate of men and women who have been in solitary is highly increased by just experiencing 7 days in solitary confinement. So the harm is profound to a human being. But thank you. There's much more to talk about. Katie?
Oh yeah, I mean, I totally agree with everything that they've been saying. I think also it's important to remember that we all live in this world together, and most people who do live in solitary confinement are going to return to society, and we want to create a world where everyone is coming out. Do you want people to have come out from solitary confinement for decades or from a more rehabilitative conditions? And so I think that it's important to remember that. And if we're looking to try to change the way our criminal justice system works and dismantle this system of warehousing people, ending this use of solitary confinement as warehousing people in prisons is a key part of that. Oh, and also I'm Katie Rose Kwan, and as Kelly said, I work for Solitary Watch, which is an investigative newsroom that reports on the use of solitary confinement on a national scale.
Thank you, Katie, Ann, and Ken. And so the next part we want to dig into is really the historical context for the practice and where it stands now in different states across the country.
Well, ironically, it started in the 1800s in Philadelphia. The American Friends Society thought people went into solitary, they would be penitent for their alleged crimes. But in California, it's been used to punish people. It's definitely a punishment regime. And as I mentioned before, California in the 70s became hundreds of thousands of people were put in jail, and with all these, reactionary laws around mass incarceration. And so we ended up with, instead of dealing with people's issues in a humane way, they just locked them up in solitary. So that was their response. But it's an ancient way of punishing people and isolating prisoners and destroying them.
Yeah, people can end up in solitary confinement for a variety of different reasons. There's very high rates of people with mental illness who end up in solitary confinement. It can be used as protective custody. People who are put in protective custody can end up in conditions that are completely confining. So there's just a lot of different ways that people end up in these conditions. But it always feels punitive, and it often is intentionally punitive, as Anne was saying.
I think if I can chime in, one of the most interesting machinations to me of this solitary confinement regime, especially in California, but it has a history in the United States, is this notion of it being an administrative action. And the rubric of the administrative action allows officials, the state, whoever, to kind of take these actions against people without following the Constitution, without following due process, without following the Eighth Amendment, without following the First Amendment. And so because they do it under the rubric of administrative action, the courts are usually reticent to step in and participate with intervening because they don't want to get involved with micromanaging prisons. And so if there's no disciplinary action, prison officials can basically say that, well, because you know so-and-so who knows so-and-so who knows so-and-so, administratively, we think that you're a threat to every prison in the state of California, and therefore we're going to neutralize you and place you in solitary confinement indefinitely, right? And because it is an administrative action, you can be placed there indefinitely without any showing that you've done anything, without any showing that you've ever committed an action, without any showing that the person that informed on you or put your name in the hat had any credibility. So it's to me, it's gone on really since the early 70s in California that they've been able to get away with this. And there's been several pieces of class action that had started in probably 1974. But based on this notion of it being an administrative action, when in reality it was punitive, it was disciplinary, is how I think the state has been able to get away with it as long as they've been able to get away with it.
I think one misconception that some people are under is that you might get assigned to solitary at sentencing, and it's absolutely something that happens within the prison system, and it's very like clouded from view. It's not happening in a courtroom, and like Kevin was saying, it can, if someone is classified to administrative segregation, they can be there indefinitely, and there's really like no recourse in many states and in many situations.
In California, our lawsuit was directly related to that. We filed, it's the violation of due process and also the Eighth Amendment because of their having no way to get out of the shoes of California. And the policy, as Ken mentioned, I mean, it's like you, and a number of African-American prisoners were basically, if they read a book by George Jackson, a very well-known prisoner who was killed in San Quentin many years ago, just reading that book, you could be validated as a gang member. And in terms of the lawsuit and our investigation, it was jailhouse lawyers, African Americans, anybody who demonstrated any leadership, was often, validated as a gang member, and it was totally indiscriminate. And so we did succeed in this case. We did settle it, and about 2,000 men came out of solitary. But as Ken mentioned, it was indefinite unless you snitched, unless you debriefed, which is another term for snitching, where you would have to basically tell the authorities everything you ever knew about yourself, your life, any other alleged gang member, anybody you knew. So you never got out of the shoe. It was indefinite and permanent, and people died in the shoe. They went insane in the shoe. And so we did, in a sense, liberate several thousand men out of the shoes of California, but there's still, through the settlement of a lawsuit, there is still, solitary confinement is still used in a limited way. So we are involved, a group of coalitions in California, civil rights coalitions, so are involved now in trying to get legislation to end solitary confinement in California. And Kelly will send you a draft of our, the bill so far. We are just developing sponsors on that bill. So theoretically, we may end it in California if we're successful.
Yeah, I do kind of want to piggyback on Ann's point, and I certainly don't want to dwell on my case because there were thousands of people that were in the shoe longer than I was. I know people that were in the shoe for up to 40 years. But just going back to the reading of the books, right? I was placed in solitary confinement, believe it or not, for reading the George Jackson book. A dear friend of mine who was in a university ethnic studies class had a George Jackson book prescribed to her for a class and a paper. She sent the book to me. I had the book. It came through regular prison channels. It wasn't contraband. It was a regular book that you can buy off of Amazon, written by George Jackson, who, as Ann mentioned, died in San Quentin in the 70s, was a well-known writer and activist who was involved with Angela Davis in the Soledad Brothers case. I had the book. It was legal to have the book. It wasn't on the contraband list. And all of a sudden, one day they came in my cell and did a cell search, and they found the book. And then they said, "Hey, who are you and why are you reading this book?" And I said, "Well, I've kind of had the book. I got the book through legal channels. It was a legitimate book to receive." And they placed me in administrative segregation and they launched an investigation on me. I hadn't done anything other than read the book and possess the book. And as a result of this so-called investigation, they thought that I was a threat to the prison system, all prisons in California, not just the prison that I was at, 33 prisons in California. I was so dangerous for reading this book that they put me in indefinite solitary confinement as a result of this. I ended up filing my own civil rights suit and challenged the system of the Department of Corrections placing African Americans specifically in solitary confinement for possessing and reading political material that other nationalities could read without recourse. So for example, just so everybody's clear, if a white person or a Hispanic person or an Asian person possessed the same exact book that I had, they could have the book and there would be no repercussions or consequences. The book only became an issue because I was African American and had the book. And so because of that tie, they made the jump from African American and reading a political book to some notion of prison gang membership, to a gang that hasn't been in existence in California prisons for quite some time. So, you know, for me, it was a throwback almost to what happened to my ancestors in slavery when they persecuted people for learning to read. So it was very offensive to me, and I spent most of the time while I was in solitary confinement trying to understand constitutionally how a state agency in the 2000s would be able to operate like a Guantanamo Bay for reading political literature. So I just want to echo that point, because a lot of people think that people are in solitary confinement behind plotting or killing. And, you know, I listened to a Secretary of Corrections one time go in front of a Senate hearing and say that everybody in solitary confinement wanted to kill police officers, and there are 3,500, you know, Army generals and all type of other crazy madness that they like to tell legislators. But I just want to put that out there that, you know, literally just based on the notion of a status, that the state can basically bury you alive indefinitely. And for many gentlemen, much more longer time than myself, that happened to.
Ken, thank you so much for sharing that. And it speaks to a bigger issue about misinformation or actual just bold-faced lies about how solitary confinement is being used. And a lot of, you know, the way that we learn about this is through news media. And so they play a huge role in shaping and crafting a narrative around these things. And so, Katie Rose, I would love it if you would start with this question about what role the media plays in shaping and changing the narrative around what solitary confinement is, who is placed there, and why.
Yeah, I'm so glad you asked this question. It's something I think about all the time. I think that the role of journalists in this landscape is to report information, accurate information about what's going on in prisons and in the use of solitary confinement that then can be used by the public, advocates, families, legislators, prison officials, even for journalists who often have greater access to institutions than the general public. Even for the media, prisons are incredibly hidden, and that's intentional. It's very difficult to know what's going on inside them. So I think that that's an important role that media plays. And I think a lot about our role on this landscape, because obviously like objectivity and truthful, accurate reporting is like the main tenet of journalism. That's what makes this a valuable service. But at the same time, I think about like a climate reporter maybe who writes accurate, true stories about the climate, but it all is based in the knowledge that climate change is real, and that's what the evidence shows. And I think that there's a similar type of reporting that happens with criminal justice reporting, where we can tell objective, true, accurate stories while still based in the overwhelming evidence that solitary confinement is causing real harm and that our criminal justice system is not working. And I think that that's an important thing, not to get too concerned about the appearance of objectivity, because some things are just proven and known facts. That's something that I think about as Solitary Watch, and I think that throughout the media landscape, different publications might have different levels of what they consider to be objective. I also think that it's really important as journalists and in media outlets to amplify the voices of the real experts here, which are people currently and formerly living in solitary confinement. And one way that we do that at Solitary Watch, we have a couple cool projects. One is called Voices from Solitary. I encourage you to go to solitarywatch.org. And it's kind of a regular column where people have handwritten dispatches from their cell, basically. And we just kind of type it up and publish it. And it can be one way for people in the public to have a more direct account directly from someone about their experiences. And we also have a reporting project going on right now where we've given grants to some journalists, including incarcerated journalists, to do journalism reporting on the conditions in their facilities and across their states. One that just came out last week in The Appeal by Juan Moreno Haynes in San Quentin is an incredible incarcerated journalist. I encourage you to check it out. It's about how getting the flu can land you in solitary confinement. So I think thinking as journalists and media outlets about what we can do to make sure that those voices are amplified, those like dispatches and reporting And also just trusting the voices of people who are incarcerated the way we would trust a source on the outside can be one mistake that some media outlets make. And I think that those are all important things to consider.
Well, I think media has been incredibly important in our fight about solitary confinement in California. Your organization, Solitary Watch, the San Francisco Bayview, the Bayview in particular during the hunger strike of 2013 was indispensable into spreading the news about the strike, because it was a publication that a lot of our prisoners listen to and get through the mail at their prisons. So, and interesting, California, because of our very, very powerful prison guards union, the CCOPA, they have blocked our prisons from actually having access to reporters. Jerry Brown, our most recent governor, and other governors have blocked. We've had bipartisan attempts to get, access of journalists to our prisons to be able to interview prisoners, and every governor so far has blocked that media access. So we're hoping under Gavin Newsom, our new governor, that he'll be more open to that. We have an extraordinarily powerful set of law enforcement, lobby, I should say, that has fought this. And because as you point out, the voices of the men and women inside are critical to understanding for Californians and whoever to understand what's really going on in our prisons. And interesting, the hunger strike of 2013 brought more media, international and national media, to this issue than ever before, to the point where the LA Times had 2 editorials saying there should be a commission that oversees CDCR. But, but the resistance is so powerful. But anyway, the role of the media is critical for these voices to be heard. And thank you for your work and the work of your organization. It's awesome.
And so kind of following up on that, just again, with the level of misinformation there is out there, one question we had from a volunteer was how to combat the notion that solitary is for the protection and safety of those who experience violence while incarcerated.
Well, I think there are 2 different issues that probably need to be understood. There's one set of solitary confinement facilities that's meant to keep out the people that they deem the worst of the worst. And then there's like another set of so-called solitary or SNY or protective custody housing units that are utilized to protect the people that have become victims or been subject to violence or other types of things because of their crime, et cetera. In most instances, probably in 90% of the instances, people that have experienced violence or can't function on the general population yard, they're put into a facility where they have full programming. They are able to go outside, they're able to go on visits, they're able to see sunshine, they're able to exercise, they're able to go shop at the canteen, they're able to live a relatively normal, if you can call prison normal, existence within inside the prison facility. Solitary, especially status-based solitary, is very different. When I experienced solitary, I was locked in a cell 24 hours a day. People say 23/7, but it's not even really 23/7. It's more like 24 hours a day. And then a couple of times during the week, if you're lucky, you get a couple hours to go outside into a kennel. I call it a kennel because that's exactly what it looks like. I mean, I remember, having conversations with my family. I used to have 2 dogs before I went to prison, and the kennel that I had for the dogs was bigger than the kennel that I was able to exercise in. So it's like an outside cell made of chain link fences that you can take 3 steps in either direction in with a toilet. So it's not even really exercise. But to get back to the issue of solitary, solitary for people who haven't done anything, in some cases that have done something, is very different than people who can't necessarily participate in general population activities, so to speak. And so I think it's important because Katie mentioned something earlier about the symptoms of what happens to people who experience solitary, the harm that's done, about public safety when people get out of prison. And it's very important to talk about the symptoms, but I also think it's important to talk about the source, right? And sometimes we forget the power that we've given the state. And we forget the fact that we built these kind of invisible walls to deal with these people that we like to consider to be invisible. Like once they go behind the wall, we kind of forget that they're there and that's somebody else's problem. And in the meantime, we've given some people a lot of power to do a lot of things to this invisible population, which I'm a part of. And I think that when you look at things like the PRLA Act, which basically scared every attorney in the country away from getting involved with prison litigation because they couldn't get paid. When legislation like that is enacted, oftentimes the public is not even aware of what's going on. And so, in our case in California and throughout the United States, like prisoners really have very little recourse, even in the court of law. They can't get legal help. Most of us can't read at an efficient level. And most of us get beat up as soon as we file the lawsuit by the attorney generals of any given state with a 12B dismissal motion. And it's almost impossible to navigate a lawsuit through the federal court system because of the PLRA Act. The cost that we have to pay, $400 or $500 to file the lawsuit, which nobody else in the country has to pay. The fact that we can't get counsel unless, we're dying on the floor and we can show pictures, which there's no camera in solitary, so how do you show pictures? I mean, it's just impossible almost. And so, great people like Ann and the Constitutional Center for Constitutional Rights on the East Coast, just this amalgamation of legal team that came together basically for free and helped us out when we did the hunger strikes. It just, it's almost a miracle that we could have brought the beast down to free this status-based solitary confinement, or at least most of it. But I do want to just mention the source, and we need to think about as citizens, the power that we give the state to do what they do, because they don't live in a vacuum or on an island. We're giving them the power to do that.
Yeah, and they're doing it in our name as the public. Like, this is allegedly for the good of society, so we should be responsible for understanding what's going on and being done in our name.
That's an understatement. In California now, we have just this year, we passed a $13 billion budget for the California Department of Corrections. And it is really obscene, albeit it has more money in it for so-called rehabilitation. But when you're in the shoe for decades or forever long, you have no programming, you have no physical contact with anybody. You have, I could go through the whole laundry list of horrible symptoms having to do with PTSD, depression. I mean, it is really, in some, it is an attempt to destroy a human being. But the state of California has allowed this to extend, and I'm repeating myself, because of the power of our lobby, the law enforcement lobby, in particular the Prison Guards Union, who is the second most powerful lobby in the state of California. And they have, been able to convince every governor to basically do their bidding. And they have an ideology which is, it's an incredibly cruel ideology of that union, which is that all these prisoners are evil, all these prisoners are guilty, all these prisoners deserve this intensive, punishment through solitary and all the impact that it has on individuals. But we are hopeful, with this pretty progressive, relatively so, Gavin Newsom, our new governor, that we're going to make some changes. And I think back to this legislation that we're sponsoring, and it looks like we're not going to have sponsors this year because of the time frames in which you have to get legislation moving throughout our system, the procedure, the process that you have to go to get legislation. But we have a couple sponsors for next year, and I think we have maybe a collective, and this goes to Katie Ross and Solitary Watch. There is a national recognition that solitary it kills people, it destroys people, it is torture. So, and all that media that people have done, and obviously the struggles of prisoners themselves and these hunger strikes have brought it to the fore. And, Ken mentions the PLRA, which is the Prison Litigation Reform Act, that actually was legislated under Bill Clinton. Clinton signed it. It totally limits the rights of prisoners. It's maybe too nerdy, but say in our lawsuit, we filed for due process violations, constitutional violations, and cruel and unusual punishment, destruction of dignity of a human being. And so we were successful, but because of the PLRA, our judge, Claudia Wilkin, in the U.S. District Court in Oakland, she could not ban solitary confinement as a result of our lawsuit because of the PLRA. It has to be narrowly framed to the claims that were originally filed, and it's limited to those men who are in solitary, in those shoes at that particular time. But I think we had the opportunity through a jury trial, if we had gone to trial, to basically eliminate it through this particular litigation. But the PLRA, limited that. It also limits lawyers, to, I guess now it's about $200 an hour and so many lawyers, particularly in California, because of our expensive, cost of living. We have so many young lawyers who want to do this litigation, who want to fight against solitary confinement and other abuses in our prisons, but cannot afford to. And so, anyway, I could go on and on, but it is a crisis of lawyers, of not having enough lawyers, because I could name, and I'm sure Ken too, about boom, boom, boom. We could name a number of issues that we could litigate tomorrow in California to bring down the system in many ways, and to pursue, more abolitionist, kind of tactics in a sense. But we don't have the lawyers because, to a great extent, they can't afford to bring these cases.
If I could I just want to add one thing on the PLRA and the lawyers' fees. I'm an anomaly because when I filed my 1983, Mayor Brown, which is a huge law firm, corporate law firm, through Stanford, and Mike Romano, who actually connected me with them once they saw the status of my 1983, they put me through their pro bono program and have just really embraced me fully and had luncheons for me and everything once I got released. And, as I urged a lot of their attorneys and other attorneys that I've talked to, is that I think that I wish that more attorneys would invest into their pro bono hours or their pro bono quotas into prison cases, because I myself have been able to navigate a little bit of the legal system for myself, but that's not the case for most people. And I've helped a lot of people try to file lawsuits in 1983s. A lot of people have good claims. I mean, people are getting their hands cut off when they go in to get a tooth pulled, and all different, just wide variety of bizarre and torturous and just unconstitutional acts are occurring behind prison walls. But it's so extremely difficult to get a lawyer. It's the PLR Act has made it almost impossible. And oftentimes when we write attorneys from prison, as Ann said, most attorneys, really aren't really that interested in it because, there's not a lot of fees involved. It's not fashionable anymore like it was maybe in the 70s and the 80s when you could, you could kind of eat off of prison law. So I just urge, I know a lot of your listeners are attorneys. I urge as much as possible that if there's hours available to pay attention to the letters that they get from prisoners. Certainly there's always cases that probably don't warrant attention, but there are so many that do, that I just beg every attorney that I talk to to invest in pro bono hours. Because if it wasn't for Mayor Brown investing in my case and walking into Judge Bettis's court in Eureka on this gang validation, they went in with like 10 attorneys and said, if you don't release Ken from the shoe and erase this erroneous validation behind Reed and George Jackson, but we're going to bring the state to its knees. And it was that show of force, it was that determination that Ann and Jewel Lobo and everybody showed that has allowed us to kind of like move forward a little bit and be successful. It's just not enough of it. For every one of me, there's like 1,000, 2,000 guys that get their lawsuit kicked out that are we're in the solitary confinement for the same reasons I was. So, I just urge as much as possible that if we can do stuff on the outside to help people inside, despite the money, despite the low fees, that we do it.
Thank you so much. And one thing I realized we didn't do to start was actually give the legal definition of solitary confinement. So if you guys can talk about, keeping in mind that, as Ken mentioned, his was 24/7. And so it doesn't always follow those constraints, but just to give more details to what we actually mean when we say solitary confinement and what the conditions of those typically are across the country.
Ann, you want to take that?
Sure. This is a Craig Haney, one of these brilliant psychologists who specialize in solitary confinement and the impact on human beings. This is his definition, and it's not just California, because California has some unique characteristics, but this is the kind of general definition, which is segregation from the mainstream prisoner population in attached housing units or freestanding facilities where prisoners are involuntarily confined in their cells for upwards of 23 hours a day or more, given only extremely limited or no opportunities for direct and normal social contact with other persons, i.e. contact that is not mediated by bars, restraints, security glass or screens and the like, and afforded extremely limited, if any, access to meaningful program of any kind. And California was even worse. No programming, no contact, no telephone calls, even if your parents are dying. Unbelievably cruel. So anyway, but that's the general definition that Craig Haney, who's an expert in this, has. But.
One thing that can be kind of difficult about trying to track the use of solitary confinement is that different prison systems use totally different names for it. Like as a journalist, if I file a public records request, sorry, it's a loud car driving by. If I file a public records request and ask for how many people are in solitary confinement, it will likely come out as 0. But if you ask how many people are spending 22 hours a day, then you start to get some numbers coming back. So it can be difficult. And then, maybe a prison will say, oh, we got rid of solitary confinement, but turns out they have people 21, 22 hours in the cell. So it's kind of like, it's not really a binary, like solitary and then fine. It's something that we have to just keep an eye on. And it's something that we have to think about as legislators might introduce reforms through that system. We have to just kind of think about whether these reforms are really giving people a more humane living condition, or if it's almost exactly the same thing, but slightly different with a new name.
You're absolutely right. In fact, in California, we just did pass legislation barring solitary confinement over 4 hours for our juveniles. And that was a big, struggle over many years. And now we're trying to do it in this legislation I spoke about before, where we're talking about maybe having the 4-hour standard, or maybe up to 10, depending on how we can negotiate with our legislators, but no more than 10 hours a day. And that that involves, of course, there's, a certain amount of time for people to sleep, but, that would be the max, because I totally agree with you that 20, 21. So from the research we've done, it's like, 4 hours does not have a negative impact on a human being, but anything more than that, it's iffy in terms of the ultimate impact.
Thank you. And Anne, some of your responses touching on the next question, which is, as advocates, whether it be in lawsuits or legislative change, like what are the alternatives that are being put forth to solitary confinement?
Well, I mentioned that legislation we're developing. I mean, so the basis of this, our concept is no isolation. In other words, if a person is acting badly, is assaulting others, there's a way to separate that person from the population and introduce mental health, all kinds of, sort of alternatives to how you treat a human being. But the issue to really treat, and this is a long discussion about how we do not really treat our prisoners, well in terms of mental health issues, which Katie Rose, mentioned before. And yet it would involve a whole different system of bringing in more mental health, more time for that particular prisoner. And I think the way it needs a whole structural change, at least in California's prisons, to allow that, to give a human being who has mental health issues, who is either acting violently towards himself or others, how to treat that person. But there are real alternatives, and other states are now developing those alternatives. And we're attempting to do that in California probably next year in terms of this legislation. But there, and Katie Rose can go into it in terms of how that can manifest itself in many ways. And there are objectively serious and valuable and reasonable alternatives to isolation.
Yeah, I mean, I totally agree with what Anne was saying, that just because maybe someone at this moment is having difficulties in general population, that does not mean that the only other alternative is to be locked alone in a cell. Like, I 100% agree that there can be therapeutic units that have programming and have support and have step downs to help people return to general population. And then we just have to keep an eye on these reforms as they're introduced, or these step downs or these alternative units, just to make sure that they don't kind of slip back into solitary and business as usual. But it's definitely possible to separate people if needed for whatever period of time without using isolation.
I think too, though, I'd just like to add that I think that whatever alternatives that we look at, it begs community involvement at the legislative level, because what I was able to see, and Ann can probably testify to this a little bit, is that they came up with step down programs for us. They wanted us to provide information and do this and do that. It was like this whole like psychoanalytical type of process that they wanted people to go through that was demeaning to us as men and as human beings. So some of these behavior modification programs that they put forth, often legislators say, oh, there's a problem, let's throw $10 million to implement X, right? And then they forget about it. And then we're allowing CDC, the same people who implemented solitary confinement, to kind of implement the program to solve solitary confinement or deal with those type of issues. And they're able to get away with that, again, going back to the earlier point, is because oftentimes it's not cute to worry about people that are in prison. You know, we forget, and we kind of want to go on with our lives and say that they did X or they did Y, and therefore they should be removed from society. But I think that the more we get involved and have discussions like this at the community level, and the more that we go put pressure on legislators to have oversight when status-based deprivations occur, when solitary confinement occurs, what type of behavior modification programs are you implementing? What is this evidence-based? What are the step-down programs that you're implementing? Is this some stuff that you found in a book from the Hitler regime, you know, type of stuff? I mean, and these are the type of programs that they actually implement at times, right? So I would just encourage all of us to always constantly be mindful and be involved as much as we can be, and encourage others to be involved at every level of community, not just community out here, but community that exists behind the walls, because as Katie mentioned so poignantly, is that most of us are going to return. And I think that everybody, I know I want to, and I know that you all probably want us to return as healthy as possible, mentally, spiritually, physically, so that way we can be productive members of the community.
Yeah, two things. I mean, it is a public health issue, and Katie Rose, you know, obviously referenced that, and that's in the Danish study that I sent you all. That is clearly an issue. When you come out of prison, you often, one, your mortality is at risk for a number of reasons, having to do with natural causes of death and unnatural causes of death, but also you are not employable in the same way because you have been mentally and physically in so many ways damaged, and you also are not a good citizen in the way you may not be able to really take care of another human being, a wife, a family member, a child, because you are not psychologically prepared for that. And one of the most terrible things about our CDCR is after we did settle this case where about a couple thousand men came out of shoes, there was no transition program, zero. In other words, you come out of solitary 10, 20, 30 years, and then you're put into this general population where you can hardly walk, your eyes are affected, you know, the bright sunlight, the noise level, the sensory deprivation before, and then the overload after. I mean, the cruelty in our dealing with the states, you know, we're fighting with the state attorney general's office. That's who represented CDCR or does. We're still in a monitoring phase of this settlement, but they could care less. I mean, I tried to bring this up before our judges, and they're mocking, they're laughing. So there's this cruelty, even through the so-called justice of our state, the attorney general's office, the kind of ideological cruelty or punishment ideologies that they have. But one of the things that we fought against also throughout this litigation is something that you mentioned, Ken, is that they had, when they were bringing people out of the shoe, you know, through a step-down program, this is sort of prior to the settlement agreement, their documents were basically what they had these men have to read and have to agree to and check off every day was basically saying, you are a terrible person. You are evil. You did a wrong crime, or you did a terrible crime. You have to rehabilitate yourself. But it was all this really cruel guilt, you know, like sort of breaking this person down to have to confess to something he probably never did or wouldn't do or whatever. So anyway, so that was their $10 million that you're talking about or more to get those documents that those men had to basically sign off on and to sort of internalize even more self-hatred, which they obviously had already been treated in such a terrible way that they already might have internalized that, but it just reinforced that.
Thank you so much. And then for the next question, because you all have spoken about how arbitrary this process is, and both in who it is used on and in race and in other ways, and the just complete lack of oversight. So if you all could just talk about the work that is being done across the country around the issue of solitary confinement, including the work that you all are doing, and then how our volunteers can be partners in that fight. That would be great.
And you want to take off on the work that we're doing in California?
Yes, I mean, one thing, again, I think I have to give all due credit and power to our leaders of the hunger strike, and starting in 2011, several strikes, and then the large one I mentioned in 2013. So there are a lot of organizations, and Ken is involved with one of the leading ones who are also partnering in our class action lawsuit, Legal Services for Prisoners with Children. There's a Families Against Solitary Confinement in Los Angeles, which they played a big role in fighting to sort of liberate our prisoners through the hunger strike. And these are families who have, loved ones in prison. And there's a lot of organizing going on the ground. And in terms of what people can do, obviously in every state of the United States, you have a legislature, which I think you all can go investigate, research, talk to your legislators about developing some kind of a end to solitary confinement in your prison system. And there has been some progress in Connecticut and in Colorado, even in Mississippi, where the ACLU filed 2 major lawsuits and ultimately brought a lot of people out of solitary. And in the research post those reforms, the violence of that prison system has gone down dramatically. So you can see even the positive aspects of, organizing and trying to get legislation passed in your particular state.
Yeah, I totally agree. There is a national coalition called Unlock the Box that's active in, I think, like 13 states. You could check out their website to see if they're involved in your state. And otherwise, if you can't find a group that's already working, you can email me at katierose@solitarywatch.org, and I can talk to my colleagues and see if we can find the group that you should be reaching out to. Writing letters to your legislators, like if there's a protest organized at the Capitol, depending on the state, reforms there might be pending legislation, there might not, but I'm sure there's some group working on this. I think keeping yourself informed is very important. I would actually recommend subscribing to the Solitary Watch newsletter. Not only do we have our own reporting, we have the other, like the Voices from Solitary I was talking about. We also do weekly roundups of like the news around the country. So it's a good way just to kind of know what lawsuits and legislation and reports and articles are taking place. And one final thing that I would definitely want to make sure you're aware of is Solitary Watch runs a pen pal program called Lifelines to Solitary, which partners people on the outside with a pen pal who's currently in solitary confinement. And I think we have like 300, 400 active pairs right now, but we're always looking for more people to sign up. And there's a link to that on Solitary Watch across the top menu bar. It's called Lifelines to Solitary, and there's information there on how you can get signed up. And that can be like a really great way to kind of directly let one person know that they're not forgotten and that there's someone out there thinking about them and help keep you engaged in the issue of solitary confinement.
Sure.
I think your last point is really, really important. And there's a project at UC Davis, students at UC Davis, this is a couple years ago, and it's an ongoing project where they did a pen pal, they developed pen pal relationships with California prisoners, and then they started visiting prisoners, and then they're bringing those prisoners who come out bringing them to UC Davis. And there's a group called, and Ken, you could talk about the Underground Scholars Program, where our UCs are taking in formerly incarcerated youth or not so youth as students, and some of them are doing just brilliant work. And so there's all kinds of ways you can interact. But I think, just having this direct relationship with a prisoner is really extraordinary and very important.
Right, as Ann mentioned, Underground Scholars here in California is a program that creates a pipeline for people coming out of prison to get into the UC system. It's currently, I think, at about 6 UC campuses, including UCLA, UC Berkeley, UC Riverside, et cetera. This is an absolutely marvelous program. We have people that have graduated from the UC system and gone on to law school, people that have gone on to get engineering degrees, policy degrees in policy at UC Berkeley. So that's a great, wonderful program. In reference to what Legal Services for Prisoners with Children is doing, as Ann mentioned, we're involved in the class action lawsuit of Ashker, which I guess is Newsom now, in the oversight through Carol Strickman, who has retired, but she still is involved, I think, to some degree in reference to the oversight of the lawsuit. A lot of the stuff that I'm doing, I'm involved heavily in policy work for people that are in prison and suffer from the effects of mass incarceration. Currently, we're involved with a policy campaign to remove involuntary servitude from the California Constitution. We're involved with creating a restoration of rights for people that have actually served their time and gotten off parole successfully, so that way they don't have face discrimination when it comes to housing, employment, voting rights, et cetera. And one of the other big campaigns that we're pushing right now is to restore voting rights to people that are on parole in California. Once a person's served their sentence and gotten out, they should be able to vote because they are currently paying taxes like me. I'm paying taxes for the work that I do, yet I have no voice. So we think that it's important for people that are actually working and participating in society in a meaningful way. They should have the right to have their voice heard. So that's some of the stuff that we're doing just in reference to policy.
Thank you all so much. Ian, did you want to add?
No, that's fine. No, right on. No.
All right. Well, I mean, not seeing any other questions from our volunteers, I think we can wrap up there. And I just want to say thank you to Katie, Rose, Ann, and Ken for sharing about your experiences and the great work that you all are doing. And to our volunteers, as I mentioned earlier, we will be sending out a follow-up email with information from Florida Representative Escamani, as well as ways in which you can get plugged into a lot of the different things our panelists have mentioned. And if you have any questions at all, please feel free to send them to volunteer@thejusticecollaborative.com. Thank you all again so much.
Thank you, Kelly.
Take care, you all. Bye.